One of the things we find from clients is that they become very anxious with the delays that the Immigration Service has in their cases. It could be a naturalization case, it could be a case involving an adjustment of status, it could be an H-1B that's been pending for too long. People ask me, what can I do? What can you do, Mr. Lawyer, about that? Many times, all a lawyer can do is make a phone call just like a client can do. We can contact your congressman just like you can do, but there's one thing extra that a lawyer can do. We can actually go to federal court and ask a federal court judge to intervene in your case to order the Immigration Service to make a timely decision in your case. This is called a mandamus action, coming from the Latin word mandate. So we go to federal court, we file a request or a complaint with the judge, and we say, hey, Judge, immigration has been taking 2 years, 3 years to adjudicate this naturalization, this I-140, this H-1B, this adjustment of status. This is unreasonable in time. We want you to order them to do this. What typically happens is very, very interesting. When you file that lawsuit, it's immediately assigned to a U.S. attorney. The U.S. attorney doesn't necessarily like their client, and they can't understand why is it taking the government 3 years to make a decision on a case when everybody else has that same case done in 4 months. So they'll go to their client, USCIS, on your behalf, kind of acting as the client's personal liaison. And what happens 95% of the time is the government lawyer will call you within about a month or 2 months and say, will you dismiss your case if we approve your client? And you say yes. So this idea that suing the government hurts your case or can damage your case, I've never seen it, and I've filed hundreds of these cases in my career. So I think in many times as clients and as lawyers, we can be much more aggressive with the government, asking them to actually do the job that we're physically paying them money to do, which is what we do when we pay filing fees, to do it in a reasonable period of time. And I've never seen any client suffer as a result of some sort of retaliatory effort from the government. Doesn't mean your case is going to be approved, but you will get either a quick decision from the government, and ultimately if they say we're going to take as long as we want, absolutely every time a federal court judge is going to order a decision within a reasonable period of time. Another reason we go to court on behalf of clients is sometimes immigration makes the wrong decision. More often than not, they make the wrong decision. Those can be appealed, but appeals take a long time, and usually they rubber stamp the appeals. So we have a client who has a case that was wrongfully denied. We typically don't appeal it internally. We go right to federal district court, and we say, federal court judge, here's what the law says. Here's what the Immigration Service did. That is wrong. We want you to issue a declaratory judgment. We want you to declare on behalf of the federal government that what the USCIS is wrong and order them to do it correctly. Once again, we've never seen retaliatory conduct from the government in doing this, but we've had much success in correcting bad decisions. And much of the things we enjoy today from benefits in difficult or controversial areas of law is a result of a positive decision in one of these declaratory judgment actions. So there's lots of reasons we can actually go to bat for our clients beyond just making a phone call. We can go to federal court using the federal court system to help our clients get the justice they deserve and that they've paid for.